How you doing?
Good.
Your name?
Yes.
Cassidy what?
Good logo.
Wow, you should have been a lawyer. Heather, I'm going to need all these files, though.
She paid him, Judge.
Yeah, I know, and he's got me dismissing them now. So how do you want me to handle it, Heather?
Do you want me to, excuse me, Judge, do you want me to pull the closed ones?
Here's what I want you to do. I'm going to take this plea to impeding on this. I'm going to dismiss the suspend. He also wants to dismiss the no proof insurance and distracted driving. I'll do that. I'm going to dismiss those from here. We're going to refund any money that we owe her. You already
Okay.
paid those?
Yes, officer, I paid my tickets on. Or I meant Judge, I'm sorry.
That's okay. How much did she pay, Heather?
She paid on the no insurance, 185. And on the distracted driving, she paid 155.
All right, here's what I'm doing. I'm going to take your plea and we'll go from there, okay? You're going to plead to impeding traffic. That's 0 points, won't go on your record. And then I'm going to dismiss the suspend, distracted driving, and no proof of insurance. That's your understanding.
Yes,
And
Judge.
you understand impeding traffic is a 0 point civil infraction.
Yes,
To
Judge.
that charge of impeding traffic, how do you plead? Responsible or not responsible?
I plead responsible.
It is accepted. 180 is your total. Go ahead and dismiss, Heather, the suspend, the distracted driving, the no proof of insurance. So I'm going to make sure I write all that down. Dismiss. No proof of insurance. Distracted driving. And suspend charge. Okay? And I'm going to charge 180, so we're going to refund all that money. All right, Heather? So you should over, it sounds like to me, 160, but they're going to have to send you a check, okay?
Thank you, Judge.
Maybe you should go to law school after that.
I'll take it into consideration.
Have a good day. Good luck to you. Wish you well. Salamat Nasser M. El Jahalam. If I'm pronouncing that, I hope I'm pronouncing that correctly. 267-840-751. Ma'am, good morning. Your name?
You want the right money set up the gentleman?
You're charged with retail fraud. You have the right to an attorney. If you want one, I will give you one. Do you want a lawyer?
Yes.
Okay, we'll set you up with a lawyer and then your lawyer will go. If somebody wrote does not speak English, you speak English though, right?
Yeah,
Okay,
No,
he doesn't matter. He does it.
it's his case, right?
No.
That's what you said. That's what you thought. Well, okay.
who's Sal?
Misunderstanding.
Wait a minute, are you selling that?
Yes.
Yeah. Woodhaven City Attorney will take you to, but we're gonna give you a lawyer.
Thank you, Your Honor.
So give the defendant lawyer and then the Woodhaven. Thank you.
Yep.
All right, go right out in the hallway. He'll set you up.
Yes, I have not heard.
I don't know, well, Shefty just gave that, and, yeah.
Oh, the felony? Or Shanky gave that too?
Shefty was solving, and that was to everything else. And even anything.
Yes, but you need to.
People against Alyssa Ann Cosby, 24B147119.
Thomas, yes, he. Shefty.
All right, your name?
Police positive.
All right, so I'm gonna read you the notes I have. This is written by probation on February 27th. Defendant is compliant, community service hours are completed, balance, food and fill. Probation department just came in and said that the victim reached out to the probation officer asserting claims that you violated the no contact provision by having somebody contact you through a third party. The probation officer asked for proof. And as of this morning, no proof has been received. Probation officer told victim to appear for prosecutor review with proof of claims. So this was scheduled for 9 o'clock. And I don't believe Mr. Cole is here, is he? I just am asking you, have you seen your
No, and I don't want to.
all right, okay. Good.
But no, I've not done anything.
Raise your right hand. You solemnly swear affirming the penalties occurred be the testimony you give in these proceedings will be the whole true self you got.
Yes,
All right, since you were in court on June 18 to 25, have you, let me see, you were in front of me on one pro.
Single payment in 6 months. How is that trying?
I just, like I said, it's hard for me to get to work or get another job because I can't drive. So the job I have right now, I wait on a ride.
What do you do for work?
Construction, carpentry, house framing.
And how many hours a week do you typically work?
Right now in the winter, not very many. I mean, probably we don't even break 30 in the winter.
So how many job applications have you put out?
Not many, not at all. Because like I said, it's kind of hard without a ride. The only reason I have this job is because I got a coworker who lives down the road from me. But we have, like I said, we haven't been working.
You know that we have a bus service, right?
Well, for like even where I live, because I'm 3 hours away.
So where do you live?
Emily City.
Are you telling me they don't have a bus service in Imlay City?
I haven't seen a bus here or Uber or none of that.
You've got to be kidding me.
I swear, Your Honor. If not, I would have already tried it.
So I've got you not proving your AA attendance, almost completed your alcohol highway safety class and made 0 payments for fines and costs. And I told you I was going to put you in jail for 5 days if you didn't get it done. So what do you think I should do for you today?
Well, I know you were pretty clear last time about the jail, so pretty sure,
So why would you want to go to jail for 5 days?
I don't want to. It's not that I want to go.
But that's what you showed me. If you didn't want to go to jail, what was you supposed to do?
Attempt to get the stuff done, which I
No,
tried.
not attempt, get it done.
Yes, sir.
This is not a try and it's a good thing and you get a medal if you try. You're supposed to cross the finish line.
Yes, sir.
I don't care how much you jog in place, go someplace, do something.
Yes, sir.
How many years you been working in construction?
Almost.
You figured out yet that it's slow in the wintertime?
Yeah, I have.
So what's your plan for making up for that? Because if I put you in jail for 5 days, you still owe me $900 and some.
Yeah.
So what's your plan?
I know I gotta see if I can pick up some side work or some.
That doesn't sound like a plan. That sounds like a hope and a prayer.
Well, no, like I said, I gotta get it done. So it's not that work's supposed to be picking back up, but it hasn't.
That's you waiting for work to happen. I'm trying to get you to understand that you need to go out and get it, not
sir.
wait for it to come to you.
Yes, sir.
I don't know that you've even picked up on that yet today.
No, I understand. Like I said, I got to get it done. I got to do better for myself, Can't be just waiting around for stuff to happen, like you said.
You want to have a hearing on this to show whether or not that you failed to do what you're supposed to do, or do you want to admit that?
I can admit to it.
You have a right to have a hearing, but if you want to admit to it, I'll let you do that. At a hearing, you'd have the right to have an attorney represent you. You'd have the right to have the burden of proof by a preponderance of the evidence be on the probation department. You'd have the right to see, hear, and question all the witnesses. You'd have the right to present your own witnesses and evidence. You'd have the right to testify or to remain silent. Those are all your rights, and I would give you all of those rights, but you also have the right to admit it if you want to. So which do you want to do? Have a hearing or admit it?
I'll admit it.
You raise your right hand, please, so I can swear you in. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Go ahead and put your hand down. The allegation against you is that you failed to provide proof of AA attendance. Is that true?
Yes, sir.
The allegation is also that you failed to pay all your fines and costs and you still owe about $900. Is that also true?
Yes, sir.
Is there anything else that you'd like to tell me by way of explanation?
No, Your Honor.
Ms. Hill, is there anything else that you'd like to add?
No, Your Honor.
All right, Mr. Ortiz Castro, I'm going to do what I told you I was going to do, which is put you in jail for 5 days.
Yes, sir.
When would you like to report?
Can we do the weekend or like Friday or something like that?
Yep.
I
Tomorrow's
also have
Friday.
I got another question concerning, like I said, do I gotta serve in Otsego County?
Yep.
So how do I go about getting up to Otsego?
Well, you can either figure out a ride or I can do a bench warrant and send the sheriff's department after you. Which would you prefer?
Can I try to figure out a ride? If not, then we can.
I think that's a great idea. So that's why I'm asking you when you want to report. I can give you till Friday at 6 p.m. or I can give you next week, Friday at 6 p.m. Which would you prefer?
Can we do next Friday just so I can get it situated and get it all figured out?
To report March 13th
Yes, sir.
at 6 p.m. to the Otsego County Jail to do 5 days.
Okay.
When you get out, you're still on probation. You still owe me $900 and some, and you still owe me proof of your AA attendance. All your other conditions of probation still apply. You understand all that?
Yes, sir.
So I'm going to ask Ms. Hill to set this for a status conference in 30 days. I need to see substantial progress or we're going to repeat this process again. Do you understand?
Yes, sir.
Any other questions that you have, sir?
No, Your Honor.
That's all for today. Thank you very much.
Thank you.
State of Michigan versus Jessica Frederick, file 25-43615-FY, set for a probation violation. Is Ms. Frederick with us?
I do not see her.
You had any contact from her?
I have not, and I'd be requesting a show cause.
All right. For the failure to appear, we'll issue a show cause. Mr. Musel joined us yet?
No, sir.
I'm gonna call that case. This is State of Michigan versus Dustin Musel, file 24-43054 ST, set for a probation violation. Mr. Musel has failed to to appear at the call of the court. Ms. Hill, what do you request for his failure to appear?
A show cause, please.
Do a show cause. State of Michigan versus Daniel Coburn, file 22-40948-SM. Mr. Coburn with us?
I do not see that name, Your Honor.
All right, Mr. Coburn has an order to show cause against him. today's date at 9 a.m. That notice was sent out on 2/23 at the address which we have for him on file on Wilkinson Road. He's failed to appear. Looks like he failed to appear on 1/22. We did a show cause. He also failed to appear in the past on 3/10 and 10/28 of 24, so we'll issue a bench warrant. State of Michigan versus Lorraine Russell, file 26-44297-SD, set for a status conference.
Your Honor, this is Lawrence Katz. I appear on behalf of Lori Russell.
Thank you. I do see Ms. Russell is present with us. Counsel, is there a resolution of this matter?
Yes, Your Honor.
What is that, please?
My client will plead to driving while impaired, and the balance of charges would be dismissed.
See, Mr. Fortier, is that an accurate statement of the agreement?
It is, Your Honor, and that also includes a dismissal of the civil infraction for the PBT refusal. I know we had signed a written plea agreement, Mr. Katz and I had, and I'm not sure if the court has already closed that other file, but that one is to be dismissed as well.
All right. Ms. Hill, are you still on with me?
I am, Your Honor.
Would you make a note to check with traffic court staff and see if that civil infraction has also been dismissed? I don't need that information right now, but just check on that if you would, please.
For Ms. Russell?
Yes.
Okay.
Thank you very much. All right, Ms. Russell, you've heard what the lawyers have said. Is that what you want to do?
Yes, sir.
If you do that, you would be giving up your right to have a trial because you'd be entering a plea and you'd be telling me what you did that was wrong instead of having the state have to prove that. Do you understand that?
Yes, sir.
Let me explain those rights to you that you would have at a hearing that you'd be giving up, though. Let me do that in a little more detail. Right now, you stand innocent until proven guilty. If you wanted to have a hearing, you'd have the right to have a trial in front of a judge or a jury. You'd have the right to have your attorney represent you at that hearing. At a trial, you would have the right to see, hear, and question all the witnesses against you. You'd have the right to have a subpoena issued so that you could require those witnesses to appear and testify. At a trial, you could testify or you could remain silent. And if you chose to remain silent, that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt. And that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those trial rights?
Yes, sir.
Do you have any questions about those trial rights?
No, sir.
Knowing all of that, do you still wish to enter your plea today?
Yes, sir.
All right, I'm going to take some testimony from you then. Would you raise your hand so I can swear you in? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, go ahead and put your hand down. Other than this plea agreement, has anybody promised you anything to get you to plead today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, sir.
All right. The amended charge of operating while visibly intoxicated would read as follows. It would say that on or about October the 20th of 2025 in Livingston Township of Otsego County, that you did operate a vehicle upon a highway, that is I-75, while you were visibly impaired due to the consumption of an alcoholic liquor or having a blood alcohol content. Is that true? Is that what happened?
Yes, sir.
Could you tell me what vehicle you were operating at that time?
I was, I don't remember exactly. It was a rental vehicle.
All right. And what did you have to drink before operating that rental car?
I had made a drink with some, about 3 Mike's Hard Lemonades and a couple of shots when I left my friend's house in Warren and had kind of sipped on it and consumed most of it by the time I got in my accident.
All right, so you say that there was an accident and police came out as a result of that?
It was into the guardrail,
All right.
yes.
Did you take any tests, blood or breath alcohol tests after your contact with the police?
Yes, I gave a blood test.
All right. Do you remember what the result of that was?
I think it was 0.14. I'm not 100% sure, sir.
Counsel, is that accurate?
It's exactly correct.
All right. Either counsel have any additional factual basis questions?
No, Your Honor.
I do not, Your Honor.
Either counsel aware of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
There are none, Your Honor.
And do both counsel believe that I've complied with the plea taking court rule?
You have.
Absolutely.
All right. I will accept Ms. Russell's plea. I find it to be knowingly, intelligently, and voluntarily made based on her answers to my questions. She has admitted to having an unlawful blood alcohol level, consuming 3 hard mics and a couple of shots in her drink, driving a rental car in Otsego County. Therefore, she's given me a proper factual basis. Give me just a second to finish my notes. All right, Ms. Russell, we're going to have to adjourn the rest of the hearing today in order for you to get what's called a substance abuse assessment. And then we will come back for sentencing after I've had a chance to review that substance abuse assessment. Your attorney can assist you with where to go and how to get that. Typically, it takes a little bit of time to get it or scheduled and then to get a report back. So we're going to look about 30 days out, but don't waste any time trying to get that process started because it does take a little bit of time before that can get accomplished. Let me give you a date for the next court date.
Do April 16th at 9 a.m.
April 16th at 9 a.m. Any conflicts for anybody on that? That's a Thursday, the 3rd Thursday in April.
That works for me, Your Honor.
Ms. Russell, is that all right with you?
I believe that'll be fine, sir.
All right. I will see you on that date. Let me just say this, because we are adjourning, anything that you do that happens to you or happens as a result of your decision-making between now and then can be used at the time of sentencing. So what I'm trying to say to you is be on your best behavior between now and then. And I'll see you on April the 16th. All right. Thank you very much. That's all.
Yes, sir. Thank you.
Your Honor, we
Thank you, Your
received
Honor.
email back that civil infraction is closed out.
All right. Thank you very much. Ms. Russell, that civil infraction has been taken care of, so you don't have to worry about that anymore. Thank you,
Yes.
Ms. Hill.
Thank you, sir.
And thank you.
Excuse me.
Okay.
All right, the next matter is State of Michigan versus Samuel Brooks, file 26-44298-SD, set for a status conference. Mr. Brooks with us?
Yes, sir.
All right, and Mr. Felton with us? All right,
Yeah.
good morning, Mr. Felton.
Good morning. For the record, John Felton appearing on behalf of Mr. Brooks, and this is a jury status conference. We've had a pretrial with the prosecuting attorney's office, and there is an agreement that Mr. Brooks would be pleading guilty to an added count of operating while impaired, in exchange for which the underlying account would be dismissed by the prosecuting attorney's office. Mr. Brooks has been assessed, and he's also been, well, I'll get into that later, but anyway, the assessment is in the court's file.
Thank you very much. Mr. Fortier, is that an accurate statement of the agreement?
It is, Judge.
All right, Mr. Brooks, you have heard what the lawyers have said. Is that what you want to do?
Yes, sir.
All right, in order to do that, you would be giving up your trial rights because you'd be admitting what you did as opposed to having the state have to prove that at a trial. Do you understand that?
Yes, sir.
There are quite a few things that happen at a trial that you'd be giving up. So let me explain those things to you so you can make an informed decision. At a trial, you'd have the right to have your attorney represent you. You'd have the right to have a trial in front of a judge or a jury. At trial, you could see, hear, and question all the witnesses against you. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. At a trial, you could testify or you could remain silent. And if you chose to remain silent, that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt. And that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
Do you understand that in entering a plea, you'd be giving up all of those rights?
Yes, sir.
Knowing all that, is that still what you want to do today, enter a plea?
Yes, sir.
All right. If you'd raise your right hand so I can swear you in and take some testimony. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, go ahead and put your hand down, sir. Other than this plea agreement, has anybody promised you anything or threatened you in any way to get you to make this agreement?
No.
Are you doing this of your own free choice and free will?
Yes, sir.
The amended charge of operating while visibly impaired would read as follows. It would say that on or about August 14th of 2025 in Chester Township of Otsego County, that you did operate a vehicle upon a highway, that is M32, while being visibly impaired from the consumption of alcohol or having a blood alcohol content above the legal limit. Is that what happened?
Yes, sir.
Can you tell me what vehicle you were operating at that time?
It was my own personal vehicle, a 2020 Chevy Silverado.
And what did you have to drink prior to operating that Silverado?
3 or 4 drinks on the golf course.
What kind of drinks?
They were vodka.
And did those drinks have the effect of making you visibly impaired?
Yes, sir.
Did you take any sort of tests with the police after you had contact with them?
Yes, sir. I took a breathalyzer and a blood alcohol test.
Do you remember what the results were?
The blood alcohol was 0.128.
Do you have any reason to dispute the accuracy of that test?
No, sir.
All right. Either counsel have any additional factual basis questions for me?
No, Your Honor.
No, I don't think so. That was in
Either
Otsego
counsel-
County.
Thank you. Either counsel have any, aware of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
No.
Both counsel agree that I have complied with the plea taking court rule?
Yes.
I do, yes.
All right. I do find that Mr. Brooks has given me a proper factual basis. He's admitted to drinking, having a blood alcohol level above the legal limit, and operating a Chevy Silverado on M32 in Otsego County. I do find that he's given me a knowing, intelligent, and voluntary plea based on his answers to my questions, so I will accept that plea. All right, I do see that there is a substance abuse assessment in the file. I have not yet had a chance to review it, but I will do so at this time. Mr. Fortier, have you had a chance to see this as well?
I have, Judge.
All right, give me just a minute, and then I'll be ready to proceed to sentencing.
be quiet. But who do I hear? Everybody just ran from me. No, nothing like teamwork.
She said.
Mr. Cook.
Good morning, Your Honor. Raymond Cook for the people. Your Honor, the people would waive any potential conflict between this honorable court and the office of the public defender. While the people do not believe that any such conflict exists, we make this waiver the appointment called that one.
And Ms. Gaines.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender. Likewise, we do not believe that there is a conflict, but if there is any conflict, we would waive it as well.
Bless you. And the court for its part also does not believe there's conflict either in Michigan court rules or the cases decided thereunder. To the extent of conflict were to exist, court would consent to hear the matters given the waivers. Court does call the case of the people of the state of Michigan versus Derek Williams, Ryan Jones.
Good morning, Your Honor. Raymond Cook for the people.
Ryan Jones.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Jones. Yeah, Mr. Jones, would you please state your name for the record?
Derek William Ryan Jones. Thank you, sir.
Okay.
What are we doing?
Your Honor, I had reached out to the MDOC. I reached out again yesterday so that I could get some sort of scheduling to speak with Mr. Jones. This morning, I still had not received a response. I would ask for an adjournment.
So you've not received a response from them at all?
I have not. I have spoken to them about the process and I have submitted my part and have not received a response to that.
Probable cause conference without objection will be March 26th,
Thank you.
2026, 9 a.m. I'll need a green sheet when I get a chance.
Yes,
That's okay. Shanasa probably has it. All right, thank you. Thank you, Mr. Jones. Is anyone else? Court calls the case of the people versus Derek Stewart.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Stewart.
I saw him up there. Oh, there he is. Mr. Stewart, can you state your name, please?
Mr. Derek Stewart. Your Honor, we were requesting adjournment. I don't think you have his competency order yet, competency referral. I think we sent you over a new one.
The last report I have is from December 8th, but I don't have a new one.
Exactly, 60 days, every 60 days, as you know, they got to come.
All right. We can always move it up. I'll adjourn it to April 2nd.
Thank you.
Competency hearing, April 2nd. 2026, 9 a.m. bond continue.
Thank you.
Court calls the case people versus Demarion White.
Andrew Childers appearing on behalf of the people.
Good morning. Please, Honorable Court, David Curtis on behalf of Demarion White is appearing via Zoom from the Juvenile Detention Center.
Mr. White, can you state your name, please?
Yeah, Demarion White.
Thank you.
Your Honor, myself and Mr. Childers are still working toward a global or a total resolution of the case. We're just asking for one more adjournment of the probable cause conference.
It's like the 19th or 26th.
The 26th, Your Honor.
Probable cause conference without objection will be adjourned to March 26th, 2026, 9 a.m. bond continue.
Thank you, Judge.
Thank you.
Tomorrow, I'll see you in the next couple of days.
Court does call the case people versus Warner Ali Thomas.
Your Honor, Judge Oda.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Ali Thomas, who is now approaching.
Yeah.
Mr. Thomas, say your name for the record.
Victor Ali Thomas.
Thank you. What are you doing?
At this time, Your Honor, obviously asking for a brief adjournment. We just need some time to finalize some free negotiations. I should be receiving you soon about the offer.
No worries. Probable cause conference, March 19th, 2026, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Calls the case people versus Abdul Latif.
Andrew Childers, appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Latif. He should be on Zoom, Your Honor.
Good morning, Your Honor. State your name, sir.
Abdulaziz Sabri Abdul Latif.
Your Honor, we're asking for a brief adjournment in this matter. The people have made an offer. I want to go over in some more detail with Mr. Abdul Latif. There's also an ancillary matter that I need to look into.
Got it. March 26, 2026, 9 a.m.
Thank you, Your Honor.
Thank
Give
you.
you a call, Mr. Latif.
You said she was in here. Oh, she left? She was? I don't like her. I don't know why she was here. For me? That has not happened in the number of years we've ever known each other, which is a long time. But okay. Court does call the case. People versus Bassam Haward. Oh, bye. Nice seeing you. Your people are doing okay. Do you? That bar's too high. They'll do, well, just mid-level. Take care.
Michael Gaddy for the defendant, Your Honor. They're bringing him.
Your name, sir?
Bassam Howard.
Thank you. What are we doing?
Your Honor, we'd ask the court to set and examine this matter.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 17th.
Yes, sir. If I could be heard on bond, Judge.
Preliminary examination in person, March 17th, 2026, 9 a.m. before Judge Moore. Yes, as to bond.
Your Honor, Mr. Howard, this is a resisting charge. He was arrested in Ypsilanti. The person's house, there was a no contact order per another matter, I believe. He does not need to go there if the court would consider releasing him on a tether. He lives with his family in Dearborn Heights, which is probably 35 miles away from there. So any tether would, GPS tether would certainly keep him from, it would alert people if he was violating a no-go to in that matter. He has a bond in that matter that is considerable, Your Honor. We'd ask the court to reduce this to something nominal that he can post and
This
with
one-
the GPS.
I think this bond is nominal. I think I have his bond in this case as $1,000. 10%.
That's what I thought too, Judge. And if the court would consider a tether provision, then that would be.
Well, in his other one, doesn't he have a tether?
Yeah, I mean, that one's 50,000 in that case. And I believe he was on probation. That's a violation of probation sentencing that's up on March 12th, a week from today with Judge Barr. So I don't think he was on a tether in that matter. I believe the violation in that matter was for not doing class work as part of a DV probation.
Response.
Given the alleged probation violation, we'd ask that bond.
Yeah, I'm not going to change the bond. I guess I would order upon his release. His bond will stay the same. He's to report for a GPS tether.
Thank you, Your Honor.
I'll talk to you. I don't know how we want to state that. But I'm continuing his bond. We'll just add the tether to it. Court calls the case People versus Sean, is it Bangora?
And Assistant Public Defender Nicholas Bukovich for Mr. Bangora, who's appearing via Zoom.
We have him. Yeah. Bangor, could you state your name, please? And turn on your camera. There you go.
Arshan Bangor.
Thank you, sir.
Your Honor, I'm requesting an adjournment to review media discovery and for further negotiations.
Probable cause conference, March 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Yeah, just look at court calls case, People versus Romeo Smith.
for people.
Public Defender Chelsea Virgils with and on behalf of Rahomanol Smith. Please state your name.
Okay.
Can we approach?
You may. Okay, we're back on the record in the Romeo Smith matter.
Thank you for the bench conference, Your Honor. I have an advice of rights form and plea form signed. The plea form does have the sentencing judge waiver box checked, but my understanding is we would be asking for him to be sentenced today.
Okay. And I have no objection to immediately sentencing him. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Nothing but the truth.
State your name, please.
Okay. This court's understanding, Mr. Smith, you're going to be pleading guilty to the charge of false pretenses 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that could be the maximum fine. You understand that? And upon your plea to that charge, that count 3, counts 1 and 2 would be dismissed. Do you understand that, sir? All right. So understanding all of that, do you still wish to plead guilty to that charge? How do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Remember, we went over those rights?
Yes, ma'am.
You understand you're giving up those rights?
Sir.
All right. Are you on probation?
No.
Are you on parole? Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Sir.
And because you believe that you're guilty of this offense?
Yes,
Pardon?
yes.
Okay. October 17, 2023, at the location of 102 Middle Drive, Ypsilanti City, Washington County, State of Michigan. Do you know what you did on that date to make you believe you're guilty of this?
I probably had a credit card and a wallet, or some old credit card, and a dude probably had,
You got to say that to me again. You found a credit card.
yeah.
Do you mind if I have what here?
Absolutely. Go on.
On October 17th, 2023, did you take somebody else's wallet?
I think I did. I think I can't really remember. I just remember being arrested or something around work, and I don't know what Middle Drive is at, but I think it's on by Forest.
Do you remember in Ypsilanti, you had somebody else's wallet and attempting to use their credit card?
Yes.
You remember doing that?
Yes.
And you knew it was somebody else's credit card?
Yes.
You knew you didn't have permission to do that?
Yes.
And you presented it at the store as your own?
Yes.
All right. And you're either you attempted or you did receive goods or services in an excess amount of $200?
No, I did. I did. I didn't get anything $200. It was, and I did have to be something else.
Okay, here's the way I'll do it. I would accept his plea to this charge, understanding that he's actually admitted to the higher charge of the possession. All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, sir.
Yes, Your Honor.
But Judge Simpson, I think, can you send it to the higher charge, to the higher courts?
Pardon?
It's just a misdemeanor charge. He's using what you admitted, which constitutes facts of the higher charge, but right now you're just entering a plea to the misdemeanor.
I'm just going to accept your plea to the misdemeanor.
Oh.
Like you wanted me to do at the beginning.
Do I go to the higher courts?
Pardon?
I go to the higher courts.
You go to the higher courts?
Like downtown.
Not for this.
No, not for this one.
All right.
In fact, we're gonna, in a very few moments, we're gonna be done with this case entirely.
Thank you.
You're welcome. All right. Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Is there anything you'd like to say before I do impose sentence on this case?
Don't have to say.
No, thank you.
Sentence of the court, the state minimums of $125 will be imposed, followed to 365 days in jail. Credit 365 days served. All right. Smith, you're all set.
Thank you, Mr. Simpson.
You're welcome. Take care of yourself, pal.
Thank you, Your Honor.
All right. Court's going to stand in brief recess.
All rise. Have you seated?
Recommendation by the evaluators, an educational group called the KDC Key 2, and then a Thinking Matters group, both of those being cognitive based, essentially awareness, education, and understanding his triggers, trying to keep him off of alcohol. He's indicated he wants to try to remain abstinent. There is a $200 request to the Michigan State Police, and I would ask that the court also consider some community service.
Thank you. Mr. Felton, allocution.
Okay, thank you. This is, as Mr. Fortier said, this is a first offense. This offense occurred on August 14th. There was a blood test. I think the result came back promptly for reasons I'm not aware. The charge didn't actually get signed until January 13th of 26. So in the meantime, while there was no charges before the charges were filed, my client, he got involved himself in the Celebrate Recovery program. That's through his church down where he lives. He commenced that on September 1st, and he attended on the 1st, the 8th, 15th, and 22nd of September. In October, he attended weekly on the 6th, 12th, 20th, and 27th. He attended on November 3rd, November 24th. And then in December, he attended on the 1st, 8th, 16th, 29th. In January, he attended on the 5th, 12th, 19th, and 26th. That's from a proof of attendance that's signed, each meeting signed by a member or by someone moderating the meeting. And he continues to go to the Celebrate Recovery program. He has advised me that since this happened, he has not had a drink. He believes that the Celebrate Recovery program is working for him. So my suggestion to the court would be to recognize the fact that he has done that. That was all done before court charges were filed voluntarily by him. And he is interested himself in not being in this situation again. But I would ask that the court recognize the fact that he has taken substantial steps on his own and order a highway safety class, but not place him on probation, Judge. I think he's demonstrated by his conduct that he intends to address these problems on his own and has been addressing them on his own.
Thank you, Mr. Felton. Mr. Brooks, is there anything that you want to tell me specifically yourself?
I'd just like to apologize for, what I did. And I agree with Mr. Felton. I completely, turned it around, and I don't plan on ever doing anything like that again. And I like that Celebrate Recovery program, and I'll do whatever classes that you would like me to do.
Well, thank you, Mr. Brooks. I am familiar with the Celebrate Recovery program. I attend a church here in the Gaylord area that has in the past, and I believe also continues to use that same type of recovery course. So I am familiar with it. I also do the sobriety court here in Otsego County, so I'm familiar with those types of activities as well through that. I am going to recognize your length of activity with Celebrate Recovery. Typically, I put people on probation for 6 months. I'm going to reduce yours to 3 months, given the fact that you've already done what appears to be about 5 or 6 months or close to that in the Celebrate Recovery program. I am going to put you on probation just for the fact that I want this to be sure that it becomes a habit. 6 months is about the minimum amount of time for that. You're close to that already. I'd like to make sure that you get through that time period so that this becomes an ingrained way of you moving forward throughout your life. I think you're on the right path. And so I'll minimize some of your fines and costs as a part of that as well, to recognize the effort that you've already made towards your sobriety. So I'm going to put you on probation for 90 days instead of 6 months. There's a $90 oversight fee for that. There's $200 in restitution. Mr. Fortier, who is the restitution to go to, please?
Michigan State Police.
All right, thank you. There's a mandatory $75 crime victim fee and a $50 justice assessment. I'm going to reduce the court cost to $200 and the fine down to $100 and a local charge of $15. Let me add all that up for you. It's a total of $730. You can pay that over the course of your probation. You may perform community service work in lieu of some of those fines and costs, discretion of the probation department. I would like you to enroll in and successfully complete the alcohol highway safety program and the victim impact panel. I believe that those are all things that you can do over the internet and via video. So that shouldn't take you very long to do that. The recommendation for you is to do some educational classes. If you wish to substitute the Key 2 educational group and the Thinking Matters group for the alcohol highway safety education class and the victim impact panel, I would not have any objection to that, but you got to do one or the other. And I'll make a note that those are optional. While you're on probation, there should be no consumption or possession of alcohol or drugs. No entrance into a business where alcohol is served by the glass. That means no bars, even if they happen to serve food. You can go into a restaurant that happens to serve alcohol, but you may not go into a bar that happens to serve food. Do you understand the difference, sir?
Yes, sir.
All right. There will be drug and or alcohol testing at the discretion of the probation department. And I'm going to require you to do 10 hours of community service work because I want you to give something back to the community for what you took from it as a result of this. I think that helps both the community and you feel like you've done something positive so that you can think well of yourself going forward, that you've learned something out of this and you've given back to the community so that you can maintain your status as a good citizen. I don't think because this is a first offense and you've taken appropriate actions, work camp and jail are not appropriate. And I believe that you're not living in Otsego County anyway, so I don't think those would be necessary at this time. Do you have any questions about the order of the court, sir?
No, sir.
Mr. Felton, any questions?
No, he should contact probation, I assume.
That is correct. Let me give you the number for that, Mr. Brooks. It's 989-731-0215.
That was 0215?
Correct, 731-0215.
Okay.
That's all for today. Thank you very much, sir. Thank you, Mr. Felton.
Thank you, Your Honor.
Thank you, Your Honor.
Sam, I'll give you a call.
All right, the next matter is the state of Michigan versus Richard Ferris, file 21-39183-SM, set for a status conference.
James Dick on behalf of Mr. Ferris, Your Honor. Mr. Ferris is appearing via Zoom.
I do see Mr. Ferris is with us. Do we have a resolution of this matter, Mr. Dick?
Not quite yet, Your Honor. We are awaiting some additional discovery, and once we have that, we should be able to proceed. I do anticipate that we should have it and be able to review it within the next 30 days.
All right, looks like we had an arraignment at the beginning of February, approximately a month ago, so we do have some time. Let me see what our next available date is in April.
You can do the 16th in the morning docket.
April 16th at 9 a.m. Any conflicts with that?
Got it. Don't believe so, Your Honor.
All right, we'll set this for a Zoom status conference at 9 a.m. on April 16th. Mr. Ferris, I want you to keep in close contact with your attorney at that next court hearing. I'd like to be able to make some decisions about how this case is to proceed. It doesn't matter to me which way you want to go, towards trial or towards a plea or making motions. Whatever you want to do is fine. I just want to be able to move the case forward at that time. So please be in contact with your attorney prior to that court date. All right, I have a notation that bond conditions were not addressed when it was originally set. So I probably need to do that in this case. Let's see if I can find anything else in the court file that says otherwise. All right, Mr. Ferris, Did you post $100 on bond already? Is that correct?
Yes, Your Honor.
All right, I'm going to continue that. That would be the same as a $1,000 cash surety or 10% bond, so that you will not have to post anything new, Mr. Ferris. I'm simply going to set the standard conditions of bond because they were not previously done. Those include that you appear at any court date that's scheduled by the court, that you abide by any judgment of the court, that you not leave the state of Michigan without permission of the court, that you not commit any crime while on release, that you immediately notify the court in writing of any change of address or telephone number that you have. While you're on, excuse me, while you're on bond, you may not use alcohol or illegal controlled substances. You may not enter into Walmart during the course of this while the case is pending, because that's the place where this is alleged to have occurred. Do you have any questions about those bond conditions, sir?
Oh, Your Honor.
All right. A copy of this will be sent to you and to your counsel so that you have that for your records. That's all for today then. Thank you very much.
Thank you.
He is everywhere but where he's supposed to be. Oh, here he is.
Your Honor, on behalf of Mr. Oliver, we're requesting to set this for an exam. I talked to him.
State your name, sir.
Tyler Oliveria.
Discovery is complete.
To my knowledge.
People have their witnesses available the 17th. Preliminary examination in person, March 17th, 2026, 9 a.m. That's before Judge Barr.
You know he's in Macomb, so it's going to take a minute to read him. You still in Macomb? Correct. Yeah, so it's going to take a minute to read him, I think. Your Honor.
Without objection. Yes.
No, let me do the talking, please. Please.
Without objection, I'll set it for the 31st, 2026, 9 a.m. before me.
I'll give you another call, sir, before the hearing.
All right, bond will continue.
Thank you.
Court calls case People versus Vincent Julian.
Ring for the people.
Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Permission to practice is granted.
Thank you. Your Honor. Oh.
Mr. Julian, can you state your name, please, sir?
Yes, Vincent Julian.
Thank you. Yes.
Your Honor, our client would like to enter a waiver.
You'd like to waive?
Yes.
Is that correct, sir?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand that you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right?
Yes, Your Honor, there was an offer sent, if I could put that on the record.
Yes.
The offer was to waive up and plead to count 1 at the circuit court, counts 2 and 3 would be dismissed. It's my understanding that defense counsel is going to be asking for a sentence of 30 days jail. People are not taking a position on that. They're free to seek that in the circuit court. That's not part of the agreement. I understand that's what they're going to be asking for.
Got it. Okay. Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 and 3 following.
Your Honor, my client stands mute and we will waive formal reading of the information and we ask that you set the case for pretrial.
And in every way, formal reading, standing mute to all three counts. Court will enter a not guilty plea. Pretrial will be set for
March 23rd at 1:30 with Judge Oda.
March 23rd, 2026, 1:30, Judge Hamud. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Nico Caillou.
Morning, Your Honor. Edward Lucas on behalf of Nico Caillou.
Yeah.
Take that one. Sir, good morning. State your name, sir.
My name is Nico Caillou.
At this time, we're in like a preliminary exam.
Discovery is complete.
To my knowledge.
People have their witnesses available the 17th. Preliminary examination in person, March 17th, 2026, 9 a.m. before Judge Barr. Bond will continue.
Thank you.
Thank you. Court calls case People versus Edna Gurma.
Thank you, Judge Simpson.
And good morning, Your Honor. Sydney Rushing, appearing on behalf of Ms. Gurma. And if Ms. Gurma, when she gets to the podium, if you could state your name for the record.
Edna Gurma.
Thank you. All right, what are we doing?
Your Honor, at this time, we're just asking for, the defense is asking just for a brief adjournment. Oh, and Your Honor, I apologize. Sydney Rushing, appearing on, standing in for Attorney Byrd. And Ms. Gurma, is that okay with you?
Yes.
Thank you. So, Your Honor, we're just seeking a very brief adjournment, either for Mr. Byrd to be able to appear or for me to get more caught up on the case. It is my understanding that there was an order that would allow Ms. Gurma to be released to treatment. I see that she is still in the Washington County Jail, but I believe that order was submitted to Your Honor.
Yes, I do have it from the sheriff's office. I will sign that. I'll approve her release. To Dawn Farm outpatient. Well, it says outpatient.
Yes, sir.
I thought it was released to inpatient.
Your Honor, I'm looking at Mr. Byrd's notes. It indicates that it was his notes say inpatient or outpatient.
Okay. All right.
That's all I have to give you for right now.
That's fine. I'll adjourn her probable cause to March 19th, 26, 9 a.m. Bond continue.
Thank you so much, Judge.
Thank you. Thank you, ma'am.
Have I understand, sir?
Pardon?
I'm trying to understand exactly what just happened.
So I've adjourned your probable cause conference for today out to the 19th, so 2 weeks out.
Yes.
I've signed an order that allows for release to treatment.
So I get out today?
I'm not sure. It's out when a bed's available or when they get you into that program.
So that's why I went. Okay. So, sir,
Huh?
honorable, gracious, wise, judicial judge of this courtroom, I don't
know that I'm all that, but go ahead.
The paperwork has been done for me to go to outpatient at Dawn's Farm.
I just signed it.
Okay, so now they'll let me go.
I don't know.
I'm just-
I don't hold the keys.
For the tether.
So I don't know how they're going to arrange.
Ms.
Thank
Gurma, they
you.
get it all arranged.
Thank you.
Thank you, Your Honor.
That was all that. And a bag of chips. Court does call the case before David Barr.
Good morning. Yasleen Singh on behalf of defendant David Barth. Mr. Barth, please state your appearance for his honor.
David Barr.
Okay, what do you want to do?
Your Honor, we are still awaiting discovery on this case. I believe there should be a protective order for a forensic interview in the court's file. And so we are asking for at least 3-week adjournment, Your Honor, so that we can obtain the outstanding discovery, review it, and make meaningful decisions thereafter.
as opposed to those meaningless ones.
Exactly.
All right. I've signed off on the protective order on it, and what I will do then, why don't I just adjourn it to April 2nd, give you about a month to do.
That'll work, Your Honor. May I address bond when at the court's leisure?
You want me to lock him up? He's out. Okay. Okay, this is gonna get ugly. Probable cause conference, April 2nd, 2026, 9 a.m. Ask the bond.
Your Honor, so I understand the charges that are before this court. My client has no criminal history whatsoever. I believe that the provision indicating any place where minors may be present is incredibly vague. I'm just asking for the court for some clarification. Does that mean he can go to the grocery store and he can go to the gas station? Could we carve out caveats? My client wants to make sure he's in compliance with his bond conditions, but that provision is so vague. I mean, minors could be present anywhere.
I see what you're talking about. It indicates playgrounds, libraries, schools, daycares, or any place where minors may be present. So do the people have a position on that?
No, Your Honor, my understanding of that provision is usually that it's those places that are specifically for children for the most part. Playgrounds, libraries, the like, but I can understand the concern that there aren't specific cutouts for them. That's specific.
Well, where does he want to, where is he worried about being that he might be in violation? You said like a grocery store.
Right, he wants to be able to go to the grocery store. He wants to be able to go to work. He wants to be able to go to the gas station. He is part of a men's group, Mankind Project. So this brings up my next request is that they have a staff meeting in Toledo on March 21st and March 22nd. I'm not sure if the court would be willing to consider him going to that. Obviously, he would remain on the tether and follow all other conditions, but that is something that he has been engaged in since well before these charges were issued, since I believe June of 2025.
Are there children at that event?
No.
Okay, so he wants to be able to go to the grocery store or to the gas station.
And work?
Does he work around children?
No.
So what prohibits him from going to work?
Nothing, Your Honor. My client is concerned that the way that this case has proceeded, he does not want there to be an allegation that he violated his bond by being around children. So we're just.
Got it.
Yeah.
So you listed basically for 3 places for me. Are the people going to have any objection to that? All right. So what I will do is I'll amend his bond conditions that he can go to work.
Okay.
Counsel, if you could provide my staff that address so that we know.
Absolutely, I will.
You can go to work, you can go to gas stations and to grocery stores.
Thank you.
So I will add those provisions. Any objection to the defendant being able to travel to that wonderful place of Toledo? I don't know why anybody wants to go, but if he wants to go, what the heck?
No.
That's like locking him up. Now, what?
What were
the dates? I think March 21st and 22nd.
That's correct.
That will include your travel time, right? Okay, so you may travel to Toledo, March 21st and 22nd.
Thank you so much, Judge.
Anything else?
No.
Boy, that took a long time.
I know, I'm sorry.
And I didn't even get to lock him up. All right, take care.
Thank you.
Court calls case, people versus DeCorey Jones.
Edward Dirks on behalf of DeCorey Jones.
Corey Jones.
Thank you.
And yeah, I'm just asking for a brief adjournment. There is another matter I'm asking to address bond at the appropriate time.
There's another matter, you said?
Yeah, there's another matter I believe is set for PCC in 2 weeks.
That's correct, Your Honor. The defendant picked up the new case where he was charged with unlawful imprisonment, GBH strangulation, assault with intent to force abortion, and interfering with electronic communications with domestic violence. He picked that up on, I believe, Sunday, and it was charged Monday.
And is it set for PCC yet?
I believe so, Your Honor. I believe Mr. Dukes is correct, and it is 2 weeks.
Pardon?
It's 2 weeks from this date.
So 19th on that one.
I believe so.
Do you see another case for him? He has another case. Is it set for the 19th?
It wasn't uploaded into the court website to where I could see it.
I don't have anything entered in January.
But he was arraigned on it. All right, what I'll do then is I'll adjourn this probable cause to the 19th. (2026) 9 a.m. If that's incorrect, we'll try to adjust it for those dates. If we can contact Paul and figure out what they did on that. As the bond.
I'm just asking for like $100 bond.
Pardon?
I'm asking for $100 bond.
Set his bond at in this one at $1,000. I'll give a 10% privilege on the PR. All right.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Craig Ivy.
Andrew Childers, appearing on behalf of
Edward Dukes on behalf of Craig Ivy.
Your name?
Craig Ivy.
All right. You're asking for an
I'm
adjournment.
asking for an adjournment.
Probable cause conference, March 26, 2026, 9 a.m. Bond continued.
Thank you.
Court calls case of the people versus Ronald Moody.
Edward Dukes on behalf of Ronald Moody in both matters.
Your name, sir?
Thank you. I'm asking for an adjournment in this matter.
Probable cause conference, March 19, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case people versus Brandon Boggs. Really, I've heard her all morning, and now she's supposed to take center stage, and she just, I can't. Where are you going? The podium's here.
Good morning, Your Honor. Assistant Public Defender Tanaka Carey. I can really, on behalf of Mr. Brandon Boggs, Mr. Boggs, state your name for the record.
Brandon Boggs, thank you.
Your Honor, I was going to set this matter for preliminary exam. I ran into my client outside and we decided we would need just one final adjournment on this matter. Please.
Bless you. What was that? Without objection, probable cause conference will be adjourned. Would you like the 19th or the 26th?
26, please, Judge.
Of course, Your Highness. March 26, 2026, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
You're welcome. That didn't sound sincere at all. It didn't, did it? You know, it's like kind of flippant. Fine, Your Honor. Thank you. Somebody's gonna have to talk to her. I heard her boss was here today. She's out of control. That's all I'll say. Court calls case people versus Jada Olive.
Morning, Your Honor, reading people.
Oh, she's.
And good morning, Your Honor. Sydney Rushing, appearing on behalf of Ms. Olive this morning. Ms. Olive, can you, they're about to unmute you, and then can you state your name? Can you state your name for me?
Jada Olive.
Thank you. What are
Your
we
Honor,
doing?
if I may.
Yes.
Ms. Olive currently has a probable cause conference scheduled for next week in another matter. So we would just ask to add this one to next week docket. I know usually we don't do a 1 week adjournment, but we just ask that so that way both cases.
No,
can be together.
that's fine if she's got another case. So 12th. So probable cause conference in this case will be adjourned to March 12th, 2026, 9 a.m.
Thank you so much, Your Honor.
Bond will continue. Thank you. Thank you,
Have a
Ms.
great day,
Olive.
you and your wonderful staff,
Thank
Judge. That's it
you.
for me today.
You do. That's 2 days in a row, Mr. Rusher.
That is, it's quite the change.
Yes. All right. Take care. Court calls the case. People versus, is it Shidera, I think is Ikiji.
Morning, Your Honor, Raymond Cook for the people. Judge McNally, Your Honor.
Good morning, Your Honor. Jonathan Sachs for Mr. Ikeji on his case ending in 1678.
Joy Yates, and on his other matters, all his other.
All right. And what are we doing?
Your Honor, for 3 of the cases, we have both parties have agreed on a referral to mental health court. So for those 3, we're seeking a short adjournment to make that happen, hopefully.
And then what about the other one?
That is correct, Your Honor. We're also seeking mental health court on that matter as well.
So we're mental health court on all of the cases.
That's not entirely true, Your Honor.
Pardon?
That's not entirely true, Your Honor.
Okay.
Case that I know, we haven't discussed a referral to mental health court on that matter.
Which one's that?
That
That's the CSC one.
Oh, Your Honor, that's the CSC one.
That's the CSC 4.
like the number.
Yeah, Your Honor, we are hoping that hopefully everything resolves together. But at this point,
Okay, so what do you want me what do you want me to do?
Your Honor, I believe we're
Same
asking for an adjournment for those matters so that we can do the mental health court referral. I'm standing.
Okay, but in the other case,
We'd
an
like to-
adjournment, are you going to have an objection to an adjournment so they all track?
No.
How long an adjournment do you need for the mental health referral?
3 weeks, please.
Conference in these matters will be adjourned March 26, 2026, 9 a.m. Bond will continue in all cases.
Your Honor, could we address bond as well, please?
Sure.
To be perfectly candid, things didn't go so well for Mr. Ikeji last time he was released, but the difference now is that he is on his medication. It's been going really well. He has, he's been in touch with folks at Community Mental Health and jail social worker. He has parental support. Mom and his dad are here. He'd be able to live with them. And because of how well he's responded to medication, that he's on his way to mental health court, our request is that you release him untethered to continue. The other piece is he has been in now for 4 months since he was arrested on the case that I'm representing him on. And so we're sort of approaching a similar amount of time to if he were convicted there as well. Thanks for considering.
Your Honor, those were the same exact arguments I was going to make in terms of bond, but really stressing what a different place he is in right now. He this is the first time he's been able to appear in court. He is significantly more stable. In addition, he's a college graduate, so he has, as he continues in his recovery, he has opportunities for employment, and he does have strong family support.
Response from the people.
Your Honor, I would defer to the court on this one. I would, however, like to raise concern that, of course, he was released at one point and it's now back before Your Honor. Of course, so I would raise that, maybe we're in a place where we want to refer to mental court. Maybe it might be best to wait those 3 weeks to see until that happens. I understand that he's in a better place, but we're still, of course, referring him to mental court, mental health court rather, for a reason. So maybe it might be best to just wait that 3 week period.
And I think that's what I'm going to do. I'm going to let that referral and that assessment go through. And then I don't mind taking a look at it again, but he didn't do well when he was out before. So I'd wait to whatever assessments or anything else, I can look at it and see prior to making a ruling that he would be released. I would be more than happy to look at, but I'm not going to do that without it. Absolutely see.
All right. Thank you, Your Honor.
Thank you. Court does call the case People versus Erica Chimente.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Chimenti. You please state your name for the record.
Erica Chimenti.
At this time, Your Honor, we're requesting a brief adjournment.
Here you go. Yes. We get rid of that. Thank you, sir. Probable cause conference will be adjourned March 26, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. Okay.
Court calls case People versus Ronald Fleming.
People.
Good morning, man. Please stop the court. Kareem Johnson, been on behalf of Mr. Fleming.
Your name, sir?
Ronald Fleming.
All right. He's here. What are we doing?
Your Honor, we're asking that this matter be set for preliminary examination.
This wasn't your one that had the code. No, okay.
No.
So all discovery is complete, counsel?
Yes, Your Honor, and there was a previous forensic examination that's been completed as well.
People have their witnesses available 17.
Do our best, Your Honor.
Preliminary examination in person, March 17th, 2026. Oh, go ahead.
I'm scheduled to start a homicide trial in Ingham County on that day.
Okay. Any objection for the people for either the 21st or 31st?
No objection to either, Your Honor.
Which would work better for you, counsel? I have March 24th and the 31st available.
The 31st, Your Honor, this case will take precedent over anything I have that morning.
All right, so on the 31st, you think?
Yes, Your
Honor. Can I ask why? Hang on one second. Can I ask why that's not on? I'll just do it this way. All right. Pardon? March 31st, 2026, 9 a.m. That's before me.
Thank you, Your Honor.
Bond will continue. Thank you. Calls case of People versus Michael Compton.
And is that on behalf of people, Your Honor?
Representative Public Defender, not curiosity, Your Honor, on behalf of Mr. Michael Clapton, who is approaching. State your names for the record.
Michael Clapton.
You may.
Hello. 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 Vote again, Your Honor. Put him on a home confinement tether GPS. That was Tuesday. He does have that tether on, to my understanding. Yes, there may be a violation. It has yet to come up in circuit court as of now. However, he's been doing everything he's supposed to do on bond, Your Honor. So I'm asking that the court, if there is a requirement to put some type of cash component, make it as minimal as possible to allow my client to continue complying as he's been doing.
All right. I would find that the setting of a personal recognizance bond under the circumstances was use of discretion by the magistrate. Setting bond. I am going to take into account the fact that, yes, it should be some type of surety bond, but I'm taking into account that, as defense has indicated, he's been doing what he's supposed to be doing, other than picking up this case while he was on bond on the other thing. But since that point, he's been cooperative, he's been doing everything. So I'm not going to require what the people had requested, and not necessarily a surety bond, but I'd be looking at it this way. I'm going to set his bond at a 10% bond in this matter, at least that way he can post it. I will also set the you want this set for preliminary?
Yes, Your Honor, please.
And your discovery is complete?
To our knowledge, Judge.
All right, discovery being complete. Would the people have their witnesses available to 17?
Double check on the. We are just waiting on the final call.
Pardon?
Requested the 911 call, but I have not received it yet.
Okay.
We're fine proceeding.
You're willing to proceed?
That's right, Your Honor.
All right. Preliminary examination in person, March 17, 2026. 9 a.m. before Judge Moore. All right. I'll set his bond. Defendant is remanded.
Thank you, Judge.
Thank you. Does call the case People versus Larry Cursor.
For the judge. Al Jabaloski, the people here. Worship, Mr. Assistant Public Defender, on behalf of Mr. Larry Kosaru.
Kosaru.
Mr. Kosaru, please ask the jail to unmute you and then state your name for the record. Judge.
You may.
Hello,
Hello, state your name, sir.
Larry Kazaru. Junior.
Close. Thank you, Judge. Notes in my file indicate that we did just receive some additional media discoveries from Mr. Kazaru. I'd be asking for an adjournment to review that with him.
All right, you want the 19th or 26th?
The 19th is fine, Judge.
Probable cause conference, March 19th, 2026, 9 a.m. Bond continues.
Thank you, Judge.
Thank you. Thank you, sir.
Thank you.
Court calls case People versus Thurman Pool.
Morning, Your Honor. Raymond Cook for the people.
That is correct.
Good morning, Kareem Johnson, on behalf of Mr. Poole. This is the co-defendant case, Your Honor.
Yes. And
He's gonna be.
the next in. Your name, sir?
Thurman Poole.
All right. What are we doing on this?
Your Honor, we're setting this for exam, and I would like to address my client's bond.
On the, who has the co-defendant?
Mr. Burgess, that's.
Is that going to be the same position on?
Setting it for exam, Your Honor?
Yes.
That's correct.
All right. And Mr. Johnson, you're not available the 17th.
That's correct, Your Honor.
All right. So I think I said his other matter for the 31st when we looked at dates. Will that work for you, Mr. Burgess?
That's right.
Is that okay? So who's? What are the numbers?
I updated your sheet for the 31st. You've got to.
Well, we'll just start loading her up at some point. I'll set preliminary examination in person. March 31st, 2026, 9 a.m. before Judge Washington. All right, Esteban.
Yeah, my client does have significant family support. His mother, his brother have been in constant contact with me. He does have a place to go and responsible people to make sure he will abide by any bond conditions. We concede that allegations made in this case are serious. However, I don't believe, other than a picture taken over an hour after the incident, there's no electronic, scientific, or personal identification that places my client at the scene of this crime, conducting any crimes, Your Honor. So because of that, we'd ask for a significant bond reduction to $15,000 cash